All right, good morning. The court will go on the record and call case 19-DR1246. If I could get entries of appearances, starting with petitioner.
I'm Catherine Elaine
Oh, I
Mosley.
think you're muted.
Catherine Elaine Mosley.
And good morning, Ms. Mosley. Ms. Mosley is appearing pro se today via WebEx, consistent with the prior court orders regarding ADA accommodations. And for respondent?
Kyle Wayne Mosley.
And Mr. Mosley is here present in the courtroom, also appearing pro se. We're set today for a 2-hour hearing on Ms. Mosley's motion for contempt. The court notes that the alleged contemptor, Mr. Mosley, was previously advised regarding the 2 counts of punitive contempt back on February 17th of 2026, and we're set for a 2-hour hearing today. The court has allotted 45 minutes to each side. I understand that the ADA accommodations do also allow for reasonable breaks, and so I will accommodate those to the extent that we're able to. I do have a matter set at 11, so we will have to conclude by 11. Before we begin the hearing, I wanted to check in with you, Ms. Mosley. There was a motion that was filed on just a couple of days ago on March 30th, titled Combined Notice of Jurisdictional Challenge and Withdraw from Proceedings. I reviewed the motion and was unclear specifically what you were asking for as it related to this contempt motion and proceedings. So why don't I start by checking in with that? What's your request today?
Well, I've been reporting crimes against children, so this really, to my understanding, and you can confirm that, is not a court where constitutional rights are read or that you handle criminal child abuse. Is that correct?
This is not a criminal court. You are
okay. Correct. So what is this court?
This is a domestic relations proceeding in a family court.
Okay, and what is family court? A civil court or criminal court? Because they read your rights in both of those courts.
Yep, so it's a civil court. Because we're here on punitive contempt, that's considered a quasi-criminal proceeding because the alleged contemptor could be sentenced to up to 6 months of jail if I find that you prove that he's in punitive contempt. But you're correct, we're here under civil proceedings and are governed by the rules of civil procedure.
Okay.
Along with the
and I was just at a civil proceeding and they read your rights and you have the right to an attorney and you invoke your constitutional rights. And if there's a crime against children reported, then that crime is tried by a district attorney, which is what I have and always have been reporting to this court. I'm in no position to be trying a case today, and I'm not going to. That's why I'm withdrawing, so we can move it to the appropriate authorities to try Mr. Mosley on crimes against children. And the only thing that I would need from you that law enforcement keeps saying is that to get in contact with the children who have been blocked for 460 days, and there's lots of reports of their mental health and physical health deteriorating and being neglected, is a warrant from you. That's it.
And I don't have the authority to issue a warrant.
Why does law enforcement think that you are the only person with authority to give them a warrant?
Let me finish my sentence. I don't have the authority to issue a warrant without the filing of a probable cause affidavit. So if it were to come, which most likely wouldn't come in front of me, it would come in front of one of the judges that was handling the warrant division. But the circumstances around a judge issuing a warrant is it's based on probable cause. And so typically what would happen is law enforcement would submit a probable cause affidavit, and then the judge who received it would review it. If there's probable cause of a crime, they would then be able to issue a warrant.
So go ahead and finish. My apologies.
Sometimes that's in conjunction with the district attorney's office. Sometimes that happens first, and then the district attorney's office reviews the information and decides if that, based on that probable cause affidavit and warrant, they can file a complaint. And if they file a complaint, that's what formally charges an individual with criminal charges. Typically, the only warrants that I have the authority to issue in a civil proceeding would be a warrant for a failure to appear for court.
What about parental interference and breaking your own custody order?
So again, that wouldn't be a warrant that I would issue. That would be, again, it would be if there was a warrant for a failure to appear, I could issue a warrant there. And otherwise, the mechanism for enforcing court orders, so violations of court orders and enforcement of those, is either through these contempt proceedings or through motions regarding parenting time disputes under 1410-129.5.
Yeah, and I did file that. The one you just referenced is filed in the actual contempt and a couple other motions. So I asked for that remedy already, and I've seen it in other cases where it's parenting contact is like within 14 days, you have to meet with such and such supervisor for the supervised parenting time. And that's not happening in this case. And that's all we need. And every single time I try to file with law enforcement, they say they can't find any probable cause. And that's ridiculous. I mean, I'm a mandated reporter. I know people who have been, in many different positions with children, and there is more than enough. This court has seen more than enough probable cause of child abuse. So much. Transcripts of children's talking, medical reports of repeat concussions, child's only crisis verbalization that they've, being neglected, no one's getting them up, they wish they had words of affirmation. I mean, this is one of the worst cases I've ever seen in my parenting groups for children. And as a teacher, no one can believe this is happening. And from the very start, the first thing I ever filed was because he pulled them out of school. And as a teacher, I know that they're truant if you don't have someone put them back in school. And then, of course, on the advisory of divorce, I reported domestic violence and concerns of child abuse. So from the get-go, based on my training, I have been told that because this is time-sensitive children's developmental windows, that they have a special court, this family court handles domestic violence and child abuse. Criminal child abuse. Otherwise, we don't need to be. There's no point in us being here. I'm not going to be my own attorney. I've paid taxes since I was 16 years old for a public person, a public attorney to represent me. And instead, it's caused me worse PTSD, which is why, because I shouldn't be here. This is a contract court. I'm not disputing a contract. I have it reporting child abuse, period. That's it.
Okay, so if there are reports of child abuse.
There is, and there is, and there's been over and over and over again. Magistrate that even reduced my time to supervise looked at it, physical evidence of it, heard testimony of it, and went and gave. And this is a pattern we know nationally. They're giving custody to abusers, and then the kids are running away or committing suicide. Now we've got name changes, schools hiding disclosure, blocking me from all contact. That's not how sole decision making works. He shouldn't even have sole decision making. What happened to the child legal representative? Why did that all get vacated? None of this makes sense, but you know what? It doesn't make sense because we shouldn't even be here. We should be in a criminal court that handles child abuse. And that's what I want. That's why I'm withdrawing. This serves no purpose. I would not be getting divorced if there was not child abuse and domestic violence against me.
Just hold on, Mr. Mosley. So, Ms. Mosley, to clarify, you're asking to withdraw your motion for contempt that was filed back on November 9th. Is that correct?
Unless you're going to appoint somebody to a public attorney to try the case, I am not qualified. I do not have a 4-year degree in criminology. I do not have a 4-year degree as an attorney. I do not want to act as an attorney anymore. I'm being restrained by the court from protecting my children. Okay? That's what I came to the court to do, to have assistance protecting them, and instead they are restraining me. He needs to be held accountable. You have broad discretion. You have demonstrated that on me, you have broad discretion to enforce the order for him, especially under these circumstances.
So just to clarify.
I need access to my children, period.
Ms.
That's a
Mosley is
federal
asking-
right, a federal parenting right, and I need law enforcement to stop blocking me from picking them up and calling sheriffs at the school, and the school not responding to anything, Children's Hospital not responding to ROIs, pediatricians not responding to ROIs. The play therapist said she hasn't been back, even though she had a suicide attempt. And but instead of enforcing the law and protecting and serving the people, they are blocking, using intimidation and armed force to block a parent, to block parental rights, which is absurd because they are looking at evidence of child abuse and they keep denying it. So I don't know why law enforcement in Jefferson County is acting like that. Apparently there's many counties in the whole United States that are acting like that, but they seem to believe that they can only find probable cause, which I don't think they're trained. Many of them are domestic abusers themselves and consuming CSAM. As I read on the reports and news, it's like maybe they don't have the correct training to know what child abuse, emotional abuse, neglect. I don't think they'd even know what that looks like. And if they do, they're letting it go and protecting him. And they seem to think that the only person that will issue a warrant is family court. Go back to family court, go back to family court. Well, why? If you're saying they don't handle child abuse, then why are they saying that you have to go back to family court? It's a runaround, and I need parenting time and contact enforced with my children so that I can get them back to safety. They were safe. I'm a certified teacher. I have 3 years in mental health counseling. They were safe. They were regulated. They were taking violin, ukulele, dance, like they were in everything very healthy. It is excruciating to, from a distance, read paperwork on their deterioration and to visibly watch it in the school pictures. So I want the law enforced, federal law that protects children and parenting rights and holds criminals accountable with investigations on child abuse. I filed with Internal Affairs. I don't even have a case number from when they supposedly started. And then I learned from the Hague Convention that he wasn't even supposed to be collecting evidence on some random email. So I turned him in. But I need someone to do their job for children.
So Ms. Mosley, I just want to confirm with you that you are asking to withdraw your motion for contempt that was filed on November 9th of 2025 and not to proceed for the hearing on contempt today. Is that correct?
Unless you're going to facilitate somebody else trying him for this case, then I am not in the position to do so.
Okay, and as I stated previously in my order, I am not aware of any legal authority that would allow statutory or legal authority that would allow me to appoint court-appointed counsel for an individual prosecuting a motion for contempt. So the court, Mr. Mosley, do you have any objection to Ms. Mosley's request to withdraw the motion for contempt and not to proceed in the hearing today?
I took the time to show up here pro se. I'd like to at least submit my evidence.
Well, if we're not going to hearing, then the court is not going to accept any evidence because I'm going to dismiss the motion for contempt and find that you're not it would go away.
That leaves me in a position where I am called something and I do not have the right to vindicate myself or not vindicate.
There aren't any allegations to vindicate yourself against if the motion is withdrawn.
I'd like to go through with proceedings today.
The court is going to
To be clear, I'm without counsel.
deny the request of Mr. Mosley to proceed to hearing today over Ms. Mosley's objection as the moving party. Ms. Mosley is asked to withdraw her motion for contempt filed on November 9th of 2025. The court grants the request and will dismiss the motion for contempt. Ms. Mosley, if you continue to have concerns around the safety of your children, reports can be made to Child Protective Services. And
They
law
have been.
enforcement.
I appreciate that, but they have been.
I know. Okay, and Ms. Mosley, this court has no jurisdiction over those agencies and their investigations. I'm just advising you of what your rights are regarding reporting concerns around child abuse. Additionally, you referenced a hearing within 14 days. That gets triggered by a motion to restrict parenting time. So if the court receives a motion to restrict parenting time that the court believes necessitates setting a hearing within 14 days, the court would operate accordingly. And then, as I stated,
you know that I've filed 3 of those and they get denied every single time, and I always have actual evidence that supports it. And then 2 weeks later, he files the same exact thing with no evidence and it gets granted. That's how the last 460 days have gone. And you can enforce this order and the parenting time right now by mandating a specific time and place for the exchange to take place with the children. That's what I need you to do. That's it.
Well, there's no exchanges authorized. What's been authorized by the court is that you have supervised parenting time.
And there's been no crime, even supervised parenting time. Like, on what grounds? That's for people coming out on probation. I'm not on probation. There's no crime. I reported a crime. So technically, you are describing being punished for reporting a crime against children, which is what family court is serving to do, is to protect Mr. Mosley from going to be investigated for a crime against children by putting me on supervised parenting time, which is an unenforceable, unconstitutional tool that's meant for people on probation coming out of incarceration. Supervised visitation, I mean, it hasn't occurred not a single time since December 21st, 2024. That makes people not sleep, parents who actually care. It has disrupted our entire lives. My entire life was planned ahead of time for my children because I do nothing but work with children in child development, and I had everything planned for the best care for my children. Okay? And none of it has been followed at all.
All right, we are here today on your motion for contempt, which you have just withdrawn and asked not to proceed on. So anything else to address will have to be filed by you as a motion with the court.
I filed every single motion. How are you going to get me in contact with my children? Supervision is for people on drugs and for people that have criminal offenses and other forms of, it doesn't even apply, but you're saying you're not even going to enforce that. That's what needs to be enforced. I need to be in contact with my children and not have police blocking me.
Again, the order of the court is that you have supervised parenting time.
Right, but you just said you have no authority to even make any sort of adjustments to federal rights or criminal rights. So that's just a contract, an administrative contract.
Right now, Ms. Mosley, we are here today on your motion for contempt, which is a mechanism to enforce the court orders, and you're asking not to proceed on that. That is what's before the court today. The court will address any other motions that are filed as they come.
Can you issue an emergency order right now for him to be put in contact?
No.
Are you a mandated reporters? Is anyone in the judicial mandated to report crimes against children if they are reported to you?
Mosley, I can make referrals to Child Protective Services just like anyone else. There's no information before me.
Because you don't look at evidence. I mean, even when you do, everybody just acts like it's not there.
The
Okay.
court finds that we have resolved the issues that are set before the court today, and so I'm going to go off the record and everyone is excused. Thank you for your appearances.
All right. Thank you.
Thank you.